Assalamu alaikum. Welcome to another session of Legal Ease, where the law is made easy for you. And the guest tonight is Mr. Ibrahim Patelia. He's an attorney, he's an experienced mediator. The topic for this evening is mediation, and we're going to try and talk particularly about mediation as a tool to resolve business disputes. Ibrahim Patelia, welcome to the program. It's good to have you. You've obviously got a lot of experience. You've been here before, so you know what it is all about. Let's start off, and we will invite listeners in a while to phone in. Start off by telling us how to use mediation.
And Jazakallah, Mohammed. I think it's always a privilege to come here. And well, mediation, we've spoken a lot about it on the show before. We've been discussing that. And I think what we must understand that it is a practical tool that can be used every day to resolve everyday disputes. And one of the things that we've seen in business is that people engage in contractual relationships, whether it's a small business buying products from a supplier, and they don't think of the possibility where they'll have conflict. And if they have that conflict, whether it's a non-payment of a contractual amount or a delivery date that has not been agreed to, then what would happen in that process, they typically would argue it out, try and find a resolution themselves, or go see their lawyers. Now, what mediation can do is short-circuit the process in a way that parties themselves, the supplier and the retailer, could engage each other and hopefully find a resolution themselves. But it brings in a third party, like yourself or myself, which can assist them to resolve a particular problem efficiently, and I think that's important.
Okay, in South Africa, obviously mediation has been used a long time, particularly in labor disputes, but even in other commercial disputes. But we want to try and focus more on mediation in the workplace, mediation for businesses. Generally, it's known as either alternative dispute resolution, but I know you and I like to talk of appropriate dispute resolution, because it's the alternative to going to court, because it's cheaper, and we've had that discussion before. Now, one of the important things is obviously there are going to be lawyers involved. So it's important, I think, to challenge lawyers. Can you share some of that about us? How do we get lawyers involved? How we get lawyers to accept mediation? Because some lawyers, and I stress some lawyers, seem to be reluctant to use mediation.
No, absolutely. I think lawyers are very concerned in terms of how they've been operating. I'm a lawyer myself, and we've been taught in a particular way, is that if there's a problem, you approach the problem in a particular way and you find resolution in a court. And that's what we've been taught, and that's what's available. And so when you tell lawyers, well, use something different, and use something that will not involve so much of your effort, and maybe reduce your fees, I think it becomes very hard for them to swallow. But I think it's quite important. We've been doing quite a bit of promotion work ourselves as mediators that go out there, and we try and encourage lawyers to use mediation to the benefit of their clients. And I think that's very important, because when you come to a lawyer as a client, the lawyer is typically going to give you a legal solution. And the legal solution can only be found through a court process or some litigation process. Now, what lawyers can do is craft their conversations a lot differently. It's by talking to their clients about what, in a business dispute, for example, what is their business needs? What are their financial needs? Where do they see their businesses going? Do they still want to engage in a future business relationship with the supplier that they have a problem with? And those things make a difference in the conversation that a lawyer could possibly have with their clients. So what I'm saying in short is that, yes, lawyers are sometimes the barrier and often the barrier. But I think we need to start educating lawyers, and lawyers also have the opportunity to engage their clients differently. I find myself in practice, by the mere fact that I engage my clients differently, they're happier. And they come and see me because I provide a different service to them. And I think clients themselves, the other angle, must start demanding that of their lawyers, to say, well, talk to me not as if I am a lawyer, Talk to me as a human being based on what I need and what I want to get out of this. Because most people don't want to get a fancy judgment. They want to get a solution and that will help them get back into what they normally do. If it's a business selling products, they want to continue doing that. Yeah.
Because a lawyer, I assume, would be trained to fight the case for their client.
Yeah.
In terms of the law says you are right, or the law says you are wrong in that sense, or the other party is wrong and you are right, so you've got a good case. If we go to court, we're going to win the case. But it's not just about winning the case, because you said something really important. Sometimes it's about the relationship as well. And I suppose in that case, mediation is really important. How do we get lawyers to really get involved? One of the things, I suppose, training at law schools. But what else can we do to ensure that we get lawyers involved and to start thinking of appropriate dispute resolution, which is mediation sometimes, so that the outcome is a win-win rather than a win-lose situation?
No, I think you raise an important point, and I think to touch on a point that you've raised a little bit earlier before your question is that lawyers will often tell you is that we don't need mediation because we would sit down with the opposition party and we negotiate because we understand that there's a need for resolution. The question is, when does that happen? How much fees have been incurred by that point? And what type of solution is being built? Because if I'm sitting across the table from my adversary who's a opposing lawyer, the kind of conversation we're going to have is a lot more robust, a lot more positional, a lot more aggressive.
And focused on the law.
Yeah, and I think that's the fundamental difference, right? Is that they focus on the law. We'll argue, we'll have this contest about who knows more about the law and sort of then try and divide what would be possible if one of us had to lose the case in court. All right? And what you raise is quite important, is that a mediator provides a very different dynamic. Because a mediator, firstly, is independent. All right? Doesn't have an interest on either side, has a broader perspective, and the kind of conversation that the mediator will have with the lawyers and their clients will be very different. The fundamental difference is that they'll talk less about the law and more about what the people need. And it seems quite strange that in a modern society that when we resolve conflict, whether it's lawyers or courts, we don't worry about what the people need. It's what the law says you need and what can be given to you in terms of the law, which is very peculiar. Yeah.
Okay, so, and then one of the things, and one of the reasons I really wanted you here as well, you went to Paris recently, you've trained a group of young students at WITS to participate at the International Mediation Competition. Tell us a bit about that. Tell us about the experiences, because this is about what, the fourth, fifth, or the sixth group that you've taken across already?
Yeah, we've taken, well, 3 groups. We've been there for about 5 years.
Okay, so about 5 groups already.
And I think you've been there as well, Mohammed. You've been there as well as a mediator and a judge. And I think what we find in it goes to the heart of your question, is that how do we change the mindset of lawyers? How do we change the mindset of users on how to approach conflict? The reality is what we're speaking about in the Western world, they've realized quite a long time ago. And they've realized that mediation provides a better solution. So they focus a lot on how lawyers, legal students, users, business people are trained in the use of resolution of conflict. So this competition is quite interesting, and I think we find ourselves participating in that because it takes a student from university, a law student, and they have this opportunity to go into a mediation process with a very experienced mediator who's been trained in commercial mediation at the International Chamber of Commerce, which is this Rolls-Royce institution in Paris. And they then have the opportunity to act out as a lawyer and a client, and they compete with another team from a different country. And it's quite a realistic competition in terms of allowing the two sides to experience the mediation, but also to negotiate quite effectively and robustly. We're finding a tremendous benefit. I mean, you yourself have assisted us quite often in developing our students, but we've seen that that process of re-engineering or relearning in terms of how we taught as lawyers is quite important because they're becoming better practitioners. And we're finding that the development of younger lawyers and the profession can only be done if you put them in an environment and show them what benefits mediation can bring. Most importantly, it's a better development in terms of the self and how we approach things from a conflict point of view.
Okay, so at the moment it was yourself and Dr. Ali Chikte from WITS,
yes,
who's been taking a team from WITS University, and I think once there was a team from Potchefstroom University.
Yes.
Those were the only two. How can we get more students involved in South Africa? Have you considered running a competition perhaps in South Africa on mediation to make people aware of the mediation process, train people here, run a competition here, and then from that choose people to go to the international?
Yeah, absolutely. I think the dream has been is that we take what we learned from the international competition and we bring it back home. So you've said that the journey has been quite long. I think 5 years ago we struggled to go, and we found ourselves in a hostel, and we've been through a process where it was self-funded. Fortunately now we're finding that the university is on board, and we're doing quite well in the international competition. What we're looking at is, and this is hopefully what we can achieve, is that universities all across the country would have localized competitions, and we can all then come and compete at a national level. One of the challenges that we have is the ability to get sponsorships to develop young students, because in fact a lot of money is spent in the big area, which is the development of your legal skills to be used in court and not in mediation. And I think we would hopefully be able to, in the next year or two, have a local competition, because the benefits are not only for students. Because if lawyers start getting involved as experienced lawyers in that competition and mediators, and we get sponsors from a corporate level, they start understanding the benefits of mediation and they experience it. So we would love to see that moment. I think it will be something very special if we can have a South African and then eventually an African competition where we encourage the use of mediation.
Okay, and I assume that you're not going to confine it, if you do run it, confine it to law students only, because businesses are involved, maybe business schools, maybe people in other faculties at university can involve, because mediators don't have to be legal people only. It doesn't have to be lawyers, it could be non-lawyers, could be skilled mediators who can come in and mediate, even if it's a legal thing.
Absolutely. That's the beauty of it, is that you could be in any profession, and we've seen that already. I mean, you could be a specialist business person, you could be an accountant, you could be an engineer, but you then find a niche in terms of resolving disputes through mediation. Your experience in that field helps you quite extensively. So absolutely, we're finding that the spectrum and the scope for this is much wider. In fact, we're seeing with a lot of family disputes, which is a lot more common, that psychologists, counselors, etc. are getting involved in the field of mediation because it's becoming quite effective in resolving family conflict, which is unfortunately quite predominant in society.
Okay. Viewers, we're going to be going for a short break in a little while. Immediately after the break, please, the lines will be open. If you need to phone in, ask Mr. Patelia for questions, anything related to mediation, whether it is mediation for businesses, whether it's mediation for labor disputes, whether it's mediation where you have disputes in the community. Please phone in with your calls. We will now take a short break. Viewers, Assalamu alaikum and welcome back to Legal Ease. Our guest tonight is Mr. Ibrahim Patelia, attorney and mediator, and we've been discussing mediation for those of you who have just joined us. And please, the lines will be open if anybody needs to call and ask Mr. Patelia for any questions that you may have. Ibrahim, just before the break, we spoke about possibility of a competition, and I suppose we need to look at things like building dispute resolution processes in contracts, because I know in labor disputes, the Labor Relations Act determines that you go for mediation first or conciliation, you then go for arbitration, but in a business contract, can you as the parties, determine that instead of going to court when you have a dispute, to build mediation into that.
Yeah, absolutely. And I think what we focus on is not trying to resolve the disputes when they arise, because often it's too late. Because by the time people come to us, whether it's a divorce matter, a labor matter, or commercial matter, they're already at war, if you want to call it as such. And you often have to get them as a mediator to a point of rationality, where they also need to understand, well, in fact, we had an issue. And it's not just that I feel he's bad or she's bad, and there was an issue. So it's important to prepare for the possibility of conflict, which is inevitable, Mohammed. We both know that, is that there's more differences than commonalities in society. So when we look at how we plan our lives, and I think this is quite important in terms of how we want to focus on effective dispute resolution, is to start looking at all of our relationships, from our personal relationships to our business relationships to our workplace relationships, and look at how we can build effective dispute resolution arrangements in place. Now, some may tell us, well, Ibrahim, what are you talking about in a marriage? How am I going to, at that point when I'm getting married, talk to my spouse about a contract that she needs to sign? Well, we know from the disputes that we deal with that, in fact, it may be better, and often better, if you do it at that point when you both still like each other. Right. Because when things go wrong, you're not going to have the opportunity to sit down and talk about how you're going to resolve it, let alone the issues that you need to decide. And the same principle applies to any relationship. I mean, even if we deal with a contractual relationship, we often want the benefit that comes with that relationship, and we want to celebrate the benefit. Yes, we've got a deal now. We don't think of the eventuality, which is very real in any relationship, that we're going to differ on something. And so one of the things that is quite important in any business planning, and it doesn't cost a lot of money. In fact, we say it's better to do proper planning in effective dispute resolution by building proper clauses in your agreements that would incorporate mediation at the right time, maybe build in arbitration clauses, and maybe if you want to use court, still use court. I mean, those things are still appropriate, but you could use other mechanisms that does not estrange the relationship. Because the processes that we're looking at, often through courts, etc., is very acrimonious. And we want to find processes that will help parties resolve their issues, but still maybe maintain their relationships. Now, not in a divorce, because that's very different, right, but hopefully in a business relationship and in an employment relationship that you'll have a better resolution.
Ibrahim, can I just stop you there? We've got a caller. Caller, your question, please.
All right. Assalamu alaikum. I want to ask you, according to the Muslims, when you are going to when you are there by the Home Affairs,
right,
is it must that you must marry according to the South African? My important question is, when you need to marry someone like South African, if you are a foreign nationalities, and they will tell you the pastor must be the qadi for you. Is that possible?
Could you just speak about more clear? I missed that last part of the question.
All right.
You said when you go to Home Affairs as a foreigner and you want to get married?
Yes. So, according to the law, is it right the pastor must be your sheikh, must be your qadi?
Oh, are you saying that they have a pastor, they have a priest there who does the marriage, and you want to know if that is correct?
Yes.
Is that your Ibrahim, did you get the question?
It
sounds like when he goes to Home Affairs, he wants to get married. Instead of getting married under Muslim rights, he gets married through a pastor, and obviously that's not a Muslim. Not quite mediation,
yes,
but the caller is called in. Do you want to answer that question?
I don't know if I'm the right person to answer that, but I think the caller must understand that that there are alims out there who have been appointed to institute civil marriages as well. There's a difference. You have a civil marriage, which is through the court processes, that is perhaps required in terms of Home Affairs, and then you have your Sharia marriage, which is your nikah. Okay, and I think there is a distinction between the two. And whether it is correct or not in terms of Sharia law, I can't really speak about that. But certainly he's not obligated to use a pastor of the Home Affairs that has been provided. I'm sure he has an option.
Yeah, and you could tell Home Affairs that you're a Muslim and you want to get married under Muslim law. You could do that.
Yeah.
Right. Okay, thank you. Ibrahim, let's go on. We were talking about mediation in contracts, and we saw often, we do work at the pro bono office, and you get family disputes, and when you settle, people say, we wish we had known about this a long time ago. We wouldn't have reached this stage if we had mediation. So but is it legally binding? Because that small business person enters into a partnership with somebody else, needs to know, I enter into this contract, I opt for mediation, and we say that's appropriate dispute resolution, or I opt for arbitration. Is that legally binding?
And I think that's an important question. I think if it is in a contract in advance of a possible dispute, so we enter into our business relationship, we sign a contract, part of that contract or agreement is there's a clause that would state if we have a dispute, we would then have to go to mediation with a mediator that we could choose, or we would defer to an association or an organization to select the mediator for us. And if that fails, we would typically use an arbitration process. And I've simplified it, but that's essentially how an ADR, or an appropriate dispute resolution clause, would be drafted in a contract. There'll be more detail, but that's essentially what we would have. It is absolutely legally binding because the parties can contract. They have the freedom to contract in terms of their dispute resolution mechanisms that they wish to have to resolve their disputes. Mediation is not governed by any South African law, and we have not as yet complied with some of the international law that would regulate mediation per se. And I've said this generally in terms of commercial issues. We do know that there's a regulation in terms of labor law. There's a regulation in terms of the Children's Act when it comes to some of the mediation that is done. But when it comes to commercial issues, it's a private agreement between parties. When it comes to the arbitration component, it's important for the arbitration agreement to be in compliance with the Arbitration Act. I think arbitration is different to mediation, where mediation allows the two people involved in the conflict to come to their own agreement. Arbitration involves those parties arguing before a third party, and that third party deciding, like a judge, who's right or wrong. Now, because there's an outcome in an arbitration process, there's greater risk if it is not compliant with our law. So for that reason, it's important when you have a clause, which is highly possible to answer your question, and it's done all the time for there to be arbitration clauses in contracts that are compliant with the Arbitration Act. But you need to make sure it is, but then it is possible for you to engage an arbitrator of your choice to resolve a dispute, and that becomes binding between the parties, the outcome, and it can be taken to court and enforced in a court process. The only restriction is obviously at this stage in terms of divorce proceedings or anything that impedes upon the private rights of a person. So you want to declare a person, for example, insane. Or, you can't take that to an arbitration process. But what we do here now, Mohammed, just as a matter of interest as well, that even with arbitration, the Law Reform Council is in fact looking at arbitration to be utilized as well for divorce matters as a matter of interest, because they're finding that even in divorce proceedings, they may need a much more effective process to resolve divorce matters. It's still not there, but that could come in the future. Yeah. But to answer your question simplistically, yes, it is absolutely binding. But please, I think for the viewers, get advice from a lawyer before you just insert mediation and arbitration. Okay? Because when you draft those clauses, they become binding, but if they're not properly drafted, you're going to be in a worse off problem than had you gone to a court process.
And you'd have to put things in like, how do you choose the mediator at the time when you have a dispute? Do you put in a particular dispute body, or do you just say, we go to mediation, we choose a particular person, but that person may not be around it. So how would you, in fact, word that clause for appropriate mediation?
I think there's a few things that must be included, and you've touched on a few. The first thing is that identify the process that you want to use. If it is mediation, understand that mediation is going to defer to a third party that will help you resolve your conflict. We would often say have that as a first step in the dispute resolution process, and if that fails, use a second step, which will be arbitration. So there could be a two-tier approach to your dispute resolution agreement. But in both instances, they are private agreements to resolve your dispute. So it requires you to appoint a third party. So often if we're in a conflict situation, we may not even agree on who the third party is going to be. You could do so up front. You could say, well, I want person so-and-so. But you've touched on the restriction of that, because that person may not be available, may not be alive, may have moved. There are various possibilities. So what we often do is defer to an organization and say, well, we would like that organization, the head of that organization, to appoint a mediator of a certain caliber. And they would normally appoint maybe or give you an option of 3, and the parties could then agree to that.
Okay.
And the type of organizations we can talk about that are available out there.
Okay. Let's stop there for a minute. Listeners, viewers, we'll take a short break. After the break, we'll continue about how do you select mediators and how do you select the organization. Assalamu alaikum again, viewers, welcome and good evening. Our guest for this evening on Legal Ease is Mr. Ibrahim Patelia, lawyer and mediator. We've been discussing mediation and appropriate dispute resolution. Just before the break, we were discussing about in the contract, how do you choose mediators, how do you choose the organization? Ibrahim, please again, how would you decide who the organization is? And I suppose as Muslims, it's easy because we've got the Muslim Mediation and Arbitration Council.
Absolutely. I think we're fortunate. The Jamiyat has for years now brought in mediation and arbitration, and they've been trained mediators and arbitrators amongst the ulama and amongst lawyers that can assist and provide the services. So that is certainly a first option. When it comes to family disputes, they have the Islamic Care Line, where they have people that are competently trained as well to assist in family conflict. But there are other private institutions as well. If there are commercial disputes that require different expertise, we work with organizations such as Tukiso Dispute Settlement. There are others like AFSA, the Arbitration Foundation of South Africa, and these are highly regarded institutions that you can defer to, and they would appoint a suitably trained and appropriate mediator or arbitrator, as the case may be, when there is a dispute. Now, we've looked at the one instance where we have mediation clauses built into a contract in advance. But it doesn't mean that if you and I have a dispute at a point where we've not sorted our contracts out effectively, that we can't use mediation. Because even at that particular point, we may say, and I have a number of cases I'm dealing with at the moment, where I'm engaging the other side's lawyers and say, well, guys, we've got a bad situation here. We've not agreed to mediation up front, but let us now agree to mediation. And if the two sides do agree, we can then follow the similar process. We can phone the Muslim Mediation and Arbitration Council or organizations like Tukiso, EFSA, etc., that are available, and we can then call upon a mediator. A few things with private mediation arrangements is that we select the mediator, we decide when that would happen, we decide on the venue, but perhaps the negative, and I also view it as a positive, is that both sides must then pay for the mediator. Okay, unlike court, the government is paying for it. This we pay for ourselves as the two parties.
But then, of course, you don't have the costs involved in hiring a lawyer to go to fight your case at court, which drags out, it takes a long time. But also, in addition to that, you probably getting skilled people, like you say, they're highly trained, who do the mediations, and it is an appropriate dispute resolution process.
Absolutely.
And
I think what you've touched on is quite important, is that the skill that these mediators have, and I think we both see it when we do train mediators. Often people walk in and say, this is airy-fairy stuff. You just get people to talk and eventually resolve. But it's a highly sophisticated process that when you experience it, that you understand that the level of skill and understanding that the mediator requires to get two parties who are at polarized positions to start talking firstly, and then secondly start understanding what they're talking, because often when we have conflict, we stop listening to the other side. We often want to just tell them what we want to tell them, and they must listen to us. And so the mediator has this amazing skill that we develop through experience and training to get people to start understanding each other. And I think that's one of the greatest benefits that mediation can offer, is that you just start understanding. And once understanding is there, solutions can start finding itself.
Okay, we've got a caller on the line.
Assalamu alaikum.
Wa alaikum salam wa rahmatullah. Can we have your question?
Gee, we have a professor. We have a situation with regard to an inheritance. Can you hear me?
Could you speak slightly louder, please?
Okay. The question is with regard to a dissolving of an estate, right?
Right.
Hello, can you hear me?
Yes, we can.
Right. Now, the parties, unfortunately, are based overseas. Some are based in South Africa, and the other parties are based overseas.
And the one party is in South Africa?
Gee.
Okay. And you want to know whether that could be mediated?
That's correct.
Okay. Certainly that can be, but let's, Ibrahim, how would you go about doing that? One party is overseas, one party is here. But for a start, you need to get the approval of the parties. Parties need to agree to it, because mediation is a voluntary process. But take it for, how would you then deal with that mediation?
This is a beautiful example of why mediation can benefit you so well, because when you deal with a legal issue and it has to go to court, you're now sitting with a situation, which country has jurisdiction, you then have to appoint lawyers in the overseas country, etc., and you're going to have a massively complex and expensive dispute to resolve. So I think Mohammed has touched on the first thing, is that you need to get consent from the other side. And then the second thing is to decide on who the mediator is going to be. And the mediation can take place with the parties physically present, or we're finding now that mediation can take place through Skype, through technology. And so the person can actually be sitting in a foreign country with whatever resources they need, and the other party could be sitting in South Africa. They've consented to a mediation agreement. They're both happy with the mediator. They're paying for those services, which means there's commitment. And so the mediator could, at worst, mediate with the parties being in two different countries. At best, is to then have both parties in the same area, whether they come to South Africa or go to the foreign country, and you could mediate it. You then don't deal with legal issues such as jurisdiction, etc. You get to the heart of the issue, and if it's an inheritance issue, there's typically financial disputes and other disputes that must be resolved. And through the development of an understanding of where the parties are coming from, at least understand what those differences are and hopefully build creative solutions. That is an ideal situation where mediation can benefit quite effectively to help you resolve that conflict. But I would still say, get proper advice, and then decide if mediation is going to assist. If the other party doesn't want to engage you, there's really nothing you can do, because then you have left with no option but to then go to court to engage them to resolve your conflict.
Okay, and that's important, because it is a voluntary process, mediation, because if the party doesn't want to, no amount of mediation is going to assist. There are sometimes, if you manage to get the person to the mediation table, then that is possible. Is the listener still on the line?
Yes, I am.
Okay. Do you want to ask a follow-up question? Have we answered your question appropriately?
I think you have. The only concern I had was, because the other party is based in the UK and us based in South Africa. But I think you did answer my question, that obviously we can we can do it through Skype or any other method. But as you said earlier, both parties have got to get the approval of the mediator, right? Or the arbitrator.
Both parties have to agree to it to start off with, and ideally both parties have to agree to who the person is that would mediate.
Okay.
Thank you. Jazakallah for your call.
Jazakallah. Assalamualaikum.
Okay. Ibrahim, very important. Mediators are highly skilled, highly trained, or should be. And we can talk a bit about, where do they get the training. But more than where do they get the training, what is involved, what are the tools that must be developed in a mediator in order to resolve disputes?
Immense patience. And I think thick skin. But I think what is quite valuable in terms of what we develop in mediation, it's not a process that you'd teach someone from start to finish, is that you do 1, 2, 3, 4. It's in fact a very creative process. And one of the core skills that we try and enhance in ourselves and in mediators is the ability to listen. I think mediators must have a very good sense of what they're hearing and what they want the parties to start understanding. Because the key to any resolution of a conflict is communication. And I harp on that continuously. Because if the mediator doesn't have the ability to listen to the right things and engage the parties in the right way, they're not going to resolve their conflict. The other thing is that the mediator has the ability, which is very powerful in mediations, we know, is that they don't keep the two parties in the room at the same time. They would be at a point, but they have this wonderful ability to separate the parties, engage one party on their own, engage the other party, and they form the conduit of the negotiations between the two parties. There's strict rules to that. And that's the reason I told the caller that even if you have to do it via Skype, it's highly possible because often mediation takes place with one party in one room and the other party in another room, and the mediator move in between the two parties. And so in that process, the mediator becomes quite a strategic enabler for the two parties to get to an agreement. But more than an agreement, I find, is an understanding, because it may not be a resolution, but it's an understanding.
Okay, so in that case, it doesn't really matter whether the person is here, whether the person is overseas. You can talk to that person on the phone. You can use email. You can use Skype. You got Viber. You got all the other thing. And the person in South Africa, the caller who called in, if you're still watching, the mediator can talk to you in South Africa and then connect to the other party in England, and you don't have to be present at that time. Because the mediator, as Ibrahim said, talks to the parties separately. If you are at the same venue, you'd be in different rooms. And instead of different rooms, you're in different countries.
Absolutely,
Okay.
which is beautiful. And I think we trying that out as well. I mean, we've got a company that specializes in mediation. And if the caller is interested, you can go to the website mediateworks.com. And we're trying to use these alternative means to get people to start at least talking to each other with a facilitator. We're finding that it's not new in terms of what's happening in the States, for example. They have online dispute resolution where the mediator and the two parties are all in different venues. And it all takes place through this virtual world. But it has its benefits in that at least people are talking. There are negatives because often we find as mediators that the human interaction often makes the difference to get people to move. It's the subtleties that do that. But I suppose technology has a place as well. Yeah.
Okay, and with that, I think let's go for our last ad break, and we'll be back thereafter. Assalamu alaikum. Good evening. Welcome to Legal Ease again. After the break, our guest for tonight, Mr. Ibrahim Patelia, who is a lawyer and mediator. We've been discussing mediation, dispute resolution as an alternative to using the courts. Ibrahim, we said we're going to talk about some of the skills. There may be viewers out there who suddenly realize maybe that's a career I want to enter. Maybe I want to be a mediator, maybe a young lawyer, or somebody says, I can do that. Where does one acquire the skills to be a mediator? And what does the training entail?
And I think that's quite key, because you've touched on one, is the aspirant mediator. They may be motivated by us now and wanting to do mediation. But also, if there are people out there who want to understand mediation, there's no better place to learn it than through a training process. But I would advise, Mohammed, is that there are many training products out there, and I think mediation is slowly becoming more and more popular in the marketplace. So you have a lot of training products offered. We've both been trained in different forums, but what has been quite useful for us is our involvement with an organization like Conflict Dynamics, who provides a world-class mediation training experience over a 5-day period. And I think the benefit of that program is that it is purely practical. Essentially, if you go through the process, and mediation is a practical skill, you go through a lot of your own mediation role plays, with the benefit of having an experienced mediator coaching you and then assessing you and giving you feedback. And this program has a potential for an international accreditation with CIDA in the UK, which is quite beneficial if you are going to be trained as a mediator.
Okay. We had a caller. It sounds like the caller's gone. Caller, if you drop the call there, could you please come back? We gladly take your call and answer your questions. So, Ibrahim, can we go? And we know, as you said, the training under Conflict Dynamics, it's internationally recognized, which in effect prepares you to be a mediator anywhere in the world.
Yeah.
And with international business, cross-border mediation is also an option. So, and of course, people can go if they want to specialize in mediation for Muslims. They can go to the Muslim Mediation and Arbitration Council. Yeah. They would advise them where to get training as well.
So as a career opportunity, and it's potentially a very viable one, because it's at the start of its journey of development. And unlike law, which has been around for quite a while, or other professions, we only can see the future uptake of mediation, especially in South Africa, in Africa, and around the world. We've seen, whether it's Brazil, India itself, in the top parts of Africa, we're finding that mediation is becoming more and more utilized in the formal dispute resolution system. So it's a wonderful career opportunity, and we need diversity, not only lawyers. I know I focused on lawyers, but we need diversity in terms of different professions, taking on the role and the skills that mediation does provide. But what's interesting as well, I know we teach at the universities as well, and we're teaching people around mediation, and often people go on to these courses not necessarily to be a mediator, but they become better negotiators in terms of business deals. They become better at resolving the conflicts in which they're exposed to. So there are various reasons why someone would want to be exposed through a mediation training. Often it's life-changing. I think we realize this as trainers, is that when people go through that process, the one thing that gets exposed is yourself, because you're the enabler, you're the tool as a mediator. So there's a lot of personal growth and development when you do go through a mediation process. A mediation training process,
right. Yeah. So it is a life skill. I mean, you can
Absolutely.
do it in sort of any conflict situation as well. Ibrahim, there are probably business people out there who say, you know, is it possible to give us some tips on, you know, a business tip list for resolving conflict? Is there such a thing? Is it possible?
I think the first step is put it on your strategy.
Right.
Don't just look at profitability and how much product you're going to sell, but part of your strategy should be an effective dispute resolution plan. And that is preemptive conflict resolution, and then when there are disputes. So whatever the relationships that there may be in a business, employment relationships, business relationships, etc., there may be family businesses, I think it's essential to speak to experts like ourselves and have a proper system put into place, proper preemptive measures. And we're also finding that we can go into sessions with business people and start training them. So development is also quite important. We spoke about being trained as mediators, But if you yourself are trained in alternative skills as a business person, it enhances your ability to resolve these conflicts yourself. And so I would put a lot of emphasis in planning and preemptive measures and training and development. And we find that a lot of the big businesses do this, but our small to medium businesses don't do it because they think it's prohibitively expensive. But then they spend a lot of money on lawyers to resolve their conflict. So I would think that part of your strategy is allocate a budget to preemptive work. And thereafter, where if you do have disputes, get the right advice. I think it's important to select your lawyers quite carefully, the type of advice, and it's important to understand that there is a process that you want to unfold when you're dealing with a dispute that talks to your business needs and not to the lawyer's needs of understanding legal problems and finding legal solutions. You need to find answers to your operational issues, your financial issues, how you're going to prosper as a business person. So I would see it as a long-term partnership with any business from the start right through to the conflict resolution system and dispute resolution system. So I would make it a top priority in businesses and in other relationships, Mohammed. It just is and I know my pet project is divorces, because it's such a high rate of divorces. We attend all of these wonderful weddings, and I often say, well, why don't we give gifts of people so that they can have proper contracts in place to resolve their conflicts. It's just an idea.
Okay, so we spoke quite a bit. We spoke about mediation as a tool to resolve business. We talked about how to use mediation. We spoke about building dispute resolution processes in contracts to include mediation. Something that you feel very strongly about is sort of marriage relationships, you know, and it can avoid divorces, I suppose, as well.
Absolutely.
And even if there is a divorce, it can make it sort of amicable, peaceful, and not parties fighting, because sometimes that's going to happen. You spoke a bit about the ICC mediation competition and the opportunity of perhaps developing a competition in South Africa. We also discussed the tools that must be developed to resolve conflict, and of course, then you gave us some business tips list for resolving conflict. Before we end, and we're about to end, just thank you for coming onto this program, Ibrahim. But with closing, what last minute tips have you got or advice for the viewers?
I think we've said a lot, and I think you've summarized it well. And I think what I would like to say is that make effective conflict resolution a priority. We often take the time to avoid our conflict. We often take the time to push it aside and defer it to the alims and the lawyers, whoever it may be. I think make it a priority in your life to develop the skills to manage your conflict as you go forward, and find the right partners to assist you in resolving the conflict effectively. And I think, Mohammed, if we all start making the priority of resolving our conflict and peace building in our relationships, we may slowly start transforming the societies in which we live in. So what I wish for is some peace, at least in some communities. Yeah.
Ibrahim, thank you very much for coming on this program, and hopefully we'll get you on the program again in future. Viewers, thank you. We've come to the end of the program. Assalamu alaikum wa rahmatullahi wa barakatuh. And Ibrahim, assalamu alaikum.